A federal judge in New York has delivered a significant blow to Justin Baldoni, dismissing his $400 million defamation and extortion lawsuit against Blake Lively, Ryan Reynolds, their publicist Leslie Sloan, and a separate $250 million libel suit against the New York Times. The ruling, issued on June 9, 2025, by U.S. District Judge Louis J. Lyman, was hailed by Lively's legal team as while the dismissal marks a major victory for Lively, Lyman granted Baldoni until June 23 to amend claims related to breach of implied covenant and tortious interference, ensuring the contentious Hollywood feud, rife with accusations of power struggles and betrayal, continues toward a March 2026 trial. The dispute originated in December 2024, when Lively filed a complaint with the California Civil Rights Department, accusing Baldoni, her co-star and director, of sexual harassment on the set of It Ends With Us, a romantic drama adapted from Colleen Hoover's novel that grossed over $351 million worldwide. Lively alleged Baldoni made inappropriate comments, performed unscripted physical actions, and created an unsafe environment. She further claimed that after raising concerns, Baldoni, Wayfarer Studios, producer Jamie Heath, and publicists Jennifer Abel and Melissa Nathan orchestrated a media campaign to discredit her, particularly after a press tour marred by rumors of on-set tension. Her federal lawsuit, filed soon after, charged Baldoni with harassment, retaliation, and emotional distress, portraying him as a director who abused his authority to suppress her. Baldoni responded on January 16, 2025, with a $400 million countersuit against Lively, Reynolds, and Sloan, alleging defamation, extortion, and invasion of privacy. He claimed Lively's accusations were fabricated to shift blame for the film's promotional fallout and to seize creative control, including over the final cut. Baldoni argued that Lively, with Reynolds and Sloan's backing, threatened to withhold promotion and attack his reputation unless he ceded directorial authority. A separate $250 million libel suit targeted the New York Times for its December 2024 article, which published text messages allegedly showing Baldoni's team planning to bury Lively. His attorney, Brian Friedman, contended the messages were misconstrued, and his team launched a website, thelawsuitinfo.com, to share untampered evidence supporting his claims. Judge Lyman's 132-page ruling decisively rejected Baldoni's case, finding that Lively's statements in her California complaint were protected under California's litigation privilege, making them immune from defamation claims. The judge determined Baldoni failed to prove Lively made defamatory statements beyond her protected complaint or that Reynolds, Sloan, or the New York Times acted with actual malice, a critical defamation requirement. Lyman also dismissed Baldoni's extortion allegations, describing Lively's alleged threats to renegotiate terms or skip promotion as legally permissible hard bargaining rather than criminal conduct. A claim tied to a document Lively allegedly never signed, which Baldoni argued obligated her to promote the film, was rejected for lack of contractual evidence. The Times reporting was protected under fair report and litigation privileges, accurately reflecting Lively's allegations. However, Lyman allowed Baldoni to amend claims for breach of implied covenant and tortious interference by June 23, offering a narrow path to continue the fight. Lively's attorneys, Ezra Hudson and Mike Gottlieb, celebrated, vowing to pursue attorneys' fees, treble damages, and punitive damages against Baldoni, Wayfarer Studios, and financier Steve Sarowitz for what they called abusive litigation. Leslie Sloan's attorney, Sigrid McCauley, emphasized her client's vindication, arguing Sloan was unfairly targeted to damage her reputation. The New York Times, through spokesperson Charlie Statlander, praised the decision as a defense of honest journalism, rejecting Baldoni's suit as a baseless attempt to suppress reporting. Lively addressed the ruling on Instagram, reflecting on the pain of a retaliatory lawsuit and framing her fight as advocacy for women's voices, tying it to broader issues of workplace accountability in the Me Too era. The feud has captivated Hollywood, fueled by high-profile involvement and public fascination. In May 2025, Baldoni's team attempted to subpoena Taylor Swift, alleging she was present during discussions about a scene Lively wanted to change and that Lively leveraged their friendship to influence set dynamics. Swift's team denounced the subpoena as a publicity stunt, and it was withdrawn after objections from Lively's attorneys, reportedly straining her relationship with Swift. On June 7, 2025, a reporter admitted a text message claiming Sloan accused Baldoni of sexual assault was a mistake, as Sloan denied using the term, undermining a key defamation claim. These developments have intensified the personal stakes, with Lively facing isolation from former allies amid the ongoing legal battle. The case highlights tensions in Hollywood's post-Me Too landscape, particularly around consent and power dynamics. Lively's allegations of body shaming and inappropriate conduct resonate with the film's domestic violence themes, spotlighting the role of intimacy coordinators. However, Baldoni's team argues Lively's active role in choreographing intimate scenes, directing camera angles, pacing, and his movements contradicts her claims of discomfort, raising questions about responsibility when actors wield significant control. Public sentiment reflected in X posts is polarized. Supporters like Amber Tamblyn back Lively, while others, including Art E. Lee Zimmerman, question whether the ruling favors the elite, though such claims lack evidence. Baldoni's team has released behind-the-scenes footage to counter Lively's narrative, while her attorneys seek sanctions for his toxic media war. Lively's legal strategy has faced challenges. On June 3, 2025, she withdrew claims of intentional and negligent infliction of emotional distress after Baldoni's team sought her medical records, a move her attorneys called routine. Judge Lyman refused to dismiss these claims on her terms, warning that failure to withdraw could limit her trial evidence. Both sides have resisted settlement, with a February 2025 letter confirming their intent to proceed to trial on March 9, 2026. Lively's Time 100 Gala speech on April 24, 2025, subtly referenced the dispute, emphasizing her commitment to using her voice for good. Baldoni's former publicist, Stephanie Jones, denied leaking texts to Lively, stating she complied with a subpoena, further complicating his narrative. The case's broader implications underscore Hollywood's struggle with accountability. The dismissal reinforces media protections, with the New York Times victory affirming fair reporting. However, the complexities, Lively's creative control versus her harassment claims, Baldoni's feminist persona versus allegations of misconduct, highlight the gray areas of consent on modern sets. As Lively prepares to testify and Baldoni considers amending his claims, the dispute continues to shape perceptions of power, public relations, and workplace transparency, with the potential to set new industry standards for